improvise. So I found something on the 13th. I'm in Tel Aviv, so I don't have storing with me. So I went into shul and I found the English book on the 13 attributes of faith. So I'm just going to read something about idolatry here. Forgive me if it's a repeat. So it says here, anybody who worships in one of the forbidden ways is considered a heretic and thereby repudiates the entire Torah, all the prophets, and everything they have ever told us until the end of time. Our Savior said that anybody who affirms that idolatry is true, even though he does not worship it, insults and disgraces Hashem's honored and awesome name. Okay, let's move on to something else. And is it okay? Continuing about worship. Anyone who worships any creation, for example, an angel, celestial sphere, constellation, star, element, or any combination thereof, is considered to be an idolater. This applies even if he knows that Hashem is God and he worships the creation because he thinks that God wants people to aggrandize and honor his creation, as kings want their ministers to be. Okay, one more thing, and sorry, I just took a picture of this. Okay, then we go on to something. Let's see. Okay, it's written something about belief. Sorry, man, I've got pictures and I have to change the. Okay, it says here, Hashem is the master of the world and of the entire universe. He created the sky and the heavens, the land and everything upon it, the oceans and all within them. He created them from absolutely nothing, as it is written. In the beginning, God created the heavens and the earth. And that's Bereshit, chapter 1, verse 1. The Hebrew word bara, created, in that verse denotes making something out of nothing, as Nachmanides commented. Okay, that's it.
All right, sounds good. I hope we've got enough time. How much time have we lost?
That was 2 minutes.
Okay, no, but you took a while to come on. I think you have been connected.
No, it was about 2 minutes. No, I was just talking about, it was 4 minutes.
Okay, let's see what we
can.
No,
not the talking, just to log on. You took longer than the rest of us.
No, I saw the link, but it was 4 minutes ago. Let's just check. 2013. That's it. It was 7 minutes ago, so it was about 5 minutes.
Okay.
So you lost 7 minutes, Damon. That's the bottom line.
Kev, can I send a new link and join this up with that? Because it might be easier. I'd rather end early.
Yes.
Okay. If you want to learn yesterday's stuff, you'll learn yesterday's stuff. I'm just a bit stuffed myself. And Rav Chia Bar Abba said in the name of Rav Yochanan, one who claims a claim of theft by a thief with respect to a lost article that he found and was safekeeping, when in fact he himself had stolen it, pays the twofold payment. What's the reason? For it's written for any lost article about which he says. Now, I just want to bring something to your attention. When I first read about this, I got confused because I was thinking that the custodian made an excuse that the object got lost in an unavoidable accident, like a wolf took the sheep that was meant to be in his care. But that's not what we're talking about here. What we are talking about here is, I'll just listen carefully. Rav Chia Bar Abba said in the name of Rav Yochanan, one who claims a claim of theft by a thief with respect to a lost article that he had found and was safekeeping, when he in fact had stolen it, pays the twofold payment. So again, if it was an object that was put into his care and he claimed it was lost through an accident and he's an unpaid custodian and witnesses come against him, he doesn't have to pay the twofold payment. This is if he happened to find a lost object and the person who owns it said to him, I hear you found my tefillin bag with a name on. I'd like it back. I left it in the shore and you found it. And he said, no, it was stolen from me. So, because it's written in a pasuk for any lost article about which he says. All right. So, the Torah basically commands the founder of a lost article to act as a custodian and safeguard it until it can be returned to its owner. And where do we see this? It's in Deuteronomy chapter 22, verse 2. And it's in the 56th daf of Bava Kamma. So guys, in our case, the one who found the article claimed that it was subsequently stolen from him, and he swore to that effect. Okay? So we learned in the 57th daf of Bava Kamma that there was a whole dispute, if you remember, whether the finder is considered like an unpaid custodian who is exempt of liability for theft, or like a paid custodian who is liable for theft. Now, if you remember that daf, the Gemara there explains that Rav Yochanan's ruling fits with either option. Why? Because even a paid custodian is liable only for ordinary theft, but not if the article is taken by an armed bandit. So in other words, if somebody sneaks in and steals the object, the paid custodian is liable. But if somebody pulls a pistol out and cocks it by his forehead and demands it, then that's not a theft. That's more like a robbery. And since it's considered an unavoidable mishap, he's not liable for that, the paid custodian. So even if we assume that a finder is considered like a paid custodian and liable for ordinary theft, we can interpret Rav Yochanan as referring to a claim of armed robbery, because that claim too can render a person liable to kefil. Okay? So either way, I generally see it as an unpaid custodian because nobody's paying him to look after the article that he found and within his care. Now, if you remember this issue about the pasuk that said for any lost article which he says, where does that come from? The full thing is in Shemot chapter 22, verse 8. Why? Because for any matter of liability, for an ox, for a donkey, for a sheep, for a garment, for any lost article about which he says, this is it, whomever the judge has found guilty shall pay twofold to his fellow. That's exactly in the pasuk. So the twofold penalty stated in the verse refers to a custodian who claims the deposit was stolen from him. He stole it himself. That's for the custodian. So Rav Yochanan now understands this clause to be basically coverage for any lost article. And he says that the twofold penalty applies as well to a normal person that wasn't elected custodian, but he found the lost item and claims that it was stolen from him, when in fact he himself stole it. So the twofold penalty is due to him too. Okay? So the teachers, so there is a bit of an issue, and we're going to go through it now. So Rav Abba bar Mamal challenges Rav Chia bar Abba from the following brisa. The first states in the passage of the unpaid custodian, if a man shall give his fellow money or vessels to safeguard. Now, just bearing in mind that every word is pertinent. When it says for a man, it obviously means an adult male, not a minor. I don't know if it does include a female, but I should imagine so, because the major issue of this inference problem is that the giving of a deposit by a minor is considered like nothing. Why? Because if you look at the law stated, Kevin, you did this before, in the passage regarding a custodian, that don't apply when the depositor is a minor. Okay? In other words, if the depositor is underage and the custodian claims that the deposit was lost or stolen, the problem is somebody that's underage needs a custodian almost to sign on their behalf. Do you know when you used to go to camp, you had to have your parents sign off for you? What do you call that if you're under legal age, Gavin?
Yeah, it's like signing Guardian. That's it. That's right.
Yeah, that's exactly it. So basically, if the depositor is a minor, he needs guardianship. So he certainly can't act as his own legal entity. And then the custodian claims that the deposit was lost or stolen. The problem is the minor can't demand that he take an oath to substantiate his claim, because he's not constituted a legal entity in the capacity to make his own decisions. So if the custodian swears that the article was stolen and he himself is found to have stolen it, he doesn't pay kefil. In other words, a claim stemming from a minor's giving doesn't have sufficient legal weight to trigger these laws. That's according to Rashi. Okay. So, from here, however, I know this only regarding a case where he gave the deposit as a minor and sued for it to be returned as a minor. So we're saying if somebody that was under 18 gave a valuable article to a custodian to look after when he was a minor, and then custodian said it was stolen, and he sued for it as a minor, there's nothing to talk about. He's not in the legal capacity to issue that. But there's a question regarding a case where he gave it as a minor and sued for it to be returned as an adult. In other words, he was 17 and a half, let's say, and he gave him a valuable goods, and then when he returned back from Israel after a year of studying, he was 18 and a half, or 18. And then we say that at that stage where he becomes a legal adult, can he sue the custodian and make sure that the court issues a oath to either render the custodian liable or off the hook? Okay, so that's the question. In other words, it's not he gave it as a minor and he's now suing as a minor. He reached adulthood, the difference of time between giving it and having sued. So we want to know if the same exclusion actually applies. Because maybe the verse, the pasuk states a man, to indicate that a person suing for return of a deposit must be an adult now at the time of his lawsuit. Not that he must have been an adult when he deposited the item with the custodian. So it means if one who is now a male of sound legal age shall give his fellow money or vessels to safeguard, it only excludes a minor who's still a minor at the time of the lawsuit from imposing an oath and a kefil, not for one who is a minor when he made the deposit, but sued after reaching adulthood. So that's what they want to know. Does it apply there? Because he's an adult, at least when he sues, maybe his claim has the gravity to cause the oath to be imposed and to cause a custodian to be liable to kefil if he responds with a false claim of theft. So how do we know what the answer is? Because the Torah therefore states, if you look at the pasuk, to the judges shall come both their claims. Meaning it means literally on the one hand, the claim of the custodian, and the other one, the claim of the depositor. But if you read into it, it actually means both their claims as meaning something else. Okay, and so what does this teach? That the law stated in the passage do not apply unless the giving of the deposit and the suing for its return are alike. In other words, both occurring during the depositor's adulthood. Okay, so if you look at the juxtaposition of the clause to the judges shall come forth both their claims. So it's the depositor's the lawsuit of the custodian, and the clause if a man shall give teaches us that suing in court is compared to giving of the deposit. Just as it's been established that the laws of the passage don't apply unless the depositor is an adult when he sues for the deposit's return, so too they don't apply unless he's an adult when he gives the deposit to the custodian. So they have to be alike in both respects. Now, if it is so that even the finder of it, now this is the question against it in the Gemara. Now, if it is so that even a finder of a lost article is liable to swear and is held liable to the twofold payment if he claims that it was stolen from him and is discovered to have stolen it himself, let a deposit given by a minor to be considered like a lost article. So all it's saying, guys, is if the claim by the owner of a lost article, who never, by the way, gave the article to the finder, has sufficient legal weight for him to demand an oath of the finder and make him liable to kefil, if there are witnesses that come against him, then the claim of an adult who sues for the return of a deposit that he actually gave a minor should have sufficient weight. Because at the time he sued, he's number one, an adult, and number two, he did give it to him. So although his giving maybe had no legal value, he shouldn't be any worse off than somebody who properly entered the other's possession without any giving at all. That's according to Rashi. Guys, do you understand the question?
Can you just repeat? You actually broke there. We didn't have a good connection. Well, I didn't, at least. I don't know about everybody else. I couldn't hear you the last like 15, 20 seconds. All right.
So, Gavin, what it's saying is something quite simple. It's saying, look, if a guy finds an object, nobody gave him permission by giving it to him, and yet the original owner can turn around and has the legal weight, being an adult, to say to him, listen, you either take an oath, or if the witness is against you, we'll extract the double payment, the kefil payment, because you claim it was stolen and you found it, but you know it's mine, it's got my markings on. So take an oath that it was stolen from you, or we'll find witnesses to say that you've kept it in some manner. So in other words, if somebody that wasn't charged with finding the object can be sued by the original owner, surely in a case where there was a purpose for giving, even if he was a minor, as a minor, when he gave to the depositor, the depositor gave to the custodian, he didn't have any legal weight. At the point at which he sues, he's now a legal adult, and why should that have less merit than somebody that just landed up finding the object? You get the question? They're equally as strong. Kev, do you get the question? Kev?
You were saying, there's just noise around here, and there's
Okay,
the two-part question you're saying about.
No. So what we said before is, listen, we would have thought if the depositor was mentally incompetent or a minor or not of the legal stature to be able to make a decision, that maybe if he gave the object when he was a minor but became of legal age, and at that point he could sue and maybe get the custodian to either take an oath or pay the kefil payment. And he's saying, so it's maybe at the age that he sues. And then the pasuk said, and they shall judge them both, meaning just as the person has to be of legal age to sue, he has to be of legal age in order that he's giving to a custodian as a depositor. He has to be of legal age as well. He has to be of sound mind in both points and being able to have a legal case and be able to extract because he's of legal age. So what we're saying, Kevin, is that, okay, so if that's the case, then there's a problem, because if you take somebody that finds a lost object, okay, and nobody gave him the object, he finds it. And in that case, the original owner can say to him, listen, it had on my tefillin box, in the casing, it had my name embroidered on it, and you say it was stolen, and I want you to take an oath because we've got witnesses that you found it. I've just been away. You didn't give it to anybody else. So if somebody that wasn't tasked with finding it is legally responsible to pay kefil and take an oath, surely somebody that was given it, even by a minor, has an equal case to be able to claim from it, because it's not like the person found it. He was actually given it. So surely it has equal weight, even if he's a minor, because there's an acknowledgement of receipt. That's the question. So, he said to Rav Chia bar Abba said to Rav Abba bar Mamal, what are we dealing with here? It's a case where the custodian consumed a deposited article while the depositor was yet a minor. So it's actually a very clever answer, Gavin.
But is it a binding contract? That's the thing, because it's a minor. That's my concern.
Okay, so we're saying it's not the point that even, listen, if a minor was too young, and you don't want to say his acknowledgement by being the depositor doesn't count for anything because he's under legal age. The person that found the article, nobody gave it to him either, and yet he's legally responsible. So how can a minor that's not legally responsible it be taken away from him, because it's even somebody that found an object, nobody put it in his care, and he still has to look after. That's the argument.
And it doesn't differentiate between somebody who finds an object from a minor or a adult. That it doesn't. You don't see that.
No, but what it says that's quite interesting is that, listen.
Because that would help if I saw that.
No, it would.
All of us.
So that's why Rav Chia Bar Abba said to Rav Abba Bar Mamal, listen, this is a case where we're dealing with the custodian who was very smart, and he consumed the deposited article while the depositor was still a minor. In other words, he's saying the deposit was never in his possession during the depositor's adulthood, and consequently it never entered into the category of something of which a valid claim, that of an adult, could be presented. In Rav Yochanan's case of the lost article, the finder took possession. He became subject to all the laws stated in the passage, even though there was no official giving, since the article had an owner who is fit to present a legal claim in court, because he's not a minor, according to Rashi. Clever.
Yeah.
Okay. So Rav Abba Bar Mamal retorts, but if the custodian consumed it when the depositor was an adult, what are you going to say about the law then? That indeed, the reply was that indeed the custodian swears over it and pays the twofold payment if he found to have stolen it himself. So basically, once the depositor reaches adulthood and becomes fit to sue, the custodian becomes liable to respond to his potential lawsuit, Gavin. So even though there was no legal act of giving, because he was too young at the time, it doesn't matter, because at the time that's reaching adulthood, it's acknowledged that he was of the age to sue. So as long as he was in possession while he reached adulthood, maybe there's a particular case as far as that's concerned. And we learned before, no, but it has been amended. So if so, instead of stating the laws that in the passage don't apply, unless the giving of the deposit and the suing for its return are alike, occurring during the depositor's adulthood, the Brisa should have stated the laws concerned in the passage don't apply unless the consumption of the deposit and the suing for its return are alike, in that they both occurred during the depositor's adulthood. Okay? So all we are saying, guys, is the critical point is not that the deposit be given by an adult, but that it was consumed after its owner became an adult. So even if it was given by a minor, the laws of the passage apply as long as it remained in existence into his adulthood. That's what's proposed here. So Rav Chia Bar Amal replies to Rav Abba Bar Mamal, okay, so indeed, I want you to amend the Brisa and teach it as saying the following, that the laws stated in the passage don't apply unless, number one, the consumption of the deposit and the suing for its return are both alike, in other words, both occurring during the depositor's adulthood. It doesn't have to be when it's given. It has to be when it's consumed. As long as the product or goods are in existence by the time the person reaches adulthood, it's now like a person finding a lost object. He is legally responsible to look after that object and can be sued. So that's one answer. Now there is another answer, because according to the Gemara, according to this other answer, the Brisa doesn't have to be amended, because Rav Ashi said the case of a deposit given by a minor isn't analogous to that of a lost article that a finder took in. Why? A lost article comes into the finder's possession on the strength of the one who is mentally competent. But this one, the deposit given by a minor who reached adulthood a little bit later, does not come into the custodian's possession on the strength of one who is mentally competent. Meaning, very simply, guys, although a person assumes custodial responsibility for an article that he takes in, even if it's not given to him, but he finds it, it only pertains to where the owner is mentally competent or a legal adult. Because when the owner is incompetent, the one who takes in his article is not a designated custodian, because in order to choose a custodian, you have to be of sound mind if you elect somebody to be have the power of attorney over your affairs or your assets. So because there's no custodianship, because the person isn't capable of making a decision, nobody can act as his representative. Okay? So it's unreasonable to hold a custodian responsible when the owner is incapable of safeguarding his own article, since the custodian can't have a greater degree of responsibility than the owner himself. That's according to the Ravad. So even if a minor reached adulthood while the article is still in the possession of the person to whom he entrusted, that person doesn't become a legal custodian at the time, because initially received the article from somebody that was legally, mentally incompetent or not of age. And because the legal status of his possession is defined at the time that he takes the article in, then if the deposit is given by a minor, the one holding it is excluded from all the laws stated in the passage of the custodians, even if it was still in existence when the depositor reached adulthood and he consumed it. Now, that is according to one opinion. Rav Ashi disagrees with the previous assertion that if the article is still in existence when the minor reached adulthood, it becomes subject to a legal claim at that time. So according to Rav Ashi, he's saying, look, as long as the article still exists when the person reaches adulthood, at that point, there's something to sue over. Doesn't matter when he was giving it, because it's like somebody finding a lost article. If there's a mentally competent and legal person that can sue him, it counts. It counts. That's according to Rav Ashi. The Ravad doesn't agree. You see. Now, I've got a question on that, and my question is very simple. Guys, we all know what's right and wrong. If somehow you found R500,000 and you know it belonged to somebody in Schottenstein and they were retarded, do they say because basically that person's mentally incompetent, you're not considered a custodian and therefore you can spend his money? That's my question against this. Because what they're trying to do is they're trying to say, listen, if the person isn't of sound mind, they can't elect somebody to have power of attorney over their affairs because they're not competent. And I'm saying you have to look at the case and say that maybe if you find something, you can't accept custodianship necessarily if the person isn't in their right mind to make a decision. But if they've given you something, you find something that belongs to them, why do they lose out just because they legally can't self-represent?
Yeah, and kids, do kids count as well as not competent or not?
Yeah, because in other words,
so that could be. So you gave the example of the Selwyn Siegel guy. What happens if you found R500,000 of a 13-year-old by mitzvah's money, and you find the same thing?
Well, that is.
You find his barmy money. It's the same problem.
It's exactly the same problem. It's exactly the same.
So it doesn't have to be somebody who's mentally handicapped or challenged. It's anybody who's not who doesn't have is not allowed to represent themselves, basically.
Exactly.
Or doesn't have the capacity to represent themselves.
And guys, if you look at the definition of statutory rape, this is the ridiculous part of the left, is that statutory rape means that if you have sex with a minor, they're not capable of making a decision in terms of emotional readiness for a sexual partner. And that's a one-time event, okay, where she may or may not get pregnant. And the person can do jail time. Yet a 14-year-old girl without a psychiatric board or parental permission can choose to have irreversible surgery that will change her gender.
Yeah, it's absolutely nuts.
Okay, so just saying, let's get back on topic. So the Gemara cites another ruling regarding a custodian who claims theft. And Rav Chia bar Abba said in the name of Rav Yochanan, one who is an unpaid custodian and claims a claim of theft by a thief with respect to a deposit that has been entrusted to him for safekeeping is not liable to the twofold payment unless he denies part of the depositor's claim and admits to part of it. Okay, so let me just explain to you what I mean. If an unpaid custodian falsely claims theft and he swore to that claim and he was found to have stolen the deposit himself, he's liable to kefil only if he initially admitted liability for part of the deposit and denied liability for part of the deposit. Okay? For example, the depositor entrusted him with 2 oxen, and the custodian admitted that one of them was lost through his negligence, but claimed that the other one was stolen. If he initially denied liability entirely, in other words, he claimed both oxen were stolen, the kefil penalty is not imposed. If he said that one of them was he was negligent over and one was stolen, the kefil penalty is imposed. Now, it's kind of hard to understand. We'll get into why. So the Rosh explains that according to Rav Yochanan, the custodian isn't even liable to take the oath in the first place unless he admits partial liability. So Rav Yochanan concurs with the Rami Bava Kamma opinion, who stated explicitly that since the court doesn't impose the oath, it doesn't impose the kefil if he swears falsely, because we learned that kefil is payable only on account of a court-imposed oath. Okay? Others explain, now this makes more sense to me, that according to Rav Yochanan, the custodian must swear, even if he issues a full denial, and partial admission is needed only for the custodian to become liable to kefil through his denial. Again, some opinions say that Rav Yochanan said either way the custodian must swear, whether it's a full denial or a partial admission. But a partial admission allows for the custodian to become liable for kefil. But it could be that after he's not prepared to take an oath, and that even if he has a full denial, that'll be enough to force him to pay. Now, it sounds a little bit weird, because this obviously is just a particular opinion. Now, what do you mean? Because if you look at it, before we get there, we want to know the reason. Because in the Chumash, it states in the passage of the unpaid custodian, for any matter about which the custodian says this is it. What do you mean this is it? Guys, that phrase, this is it, means this is all I owe you and nothing more. That's what the phrase this is it means in the Chumash. It's all I owe you. This is the amount, that's it, nothing more. Whomever the judge has found guilty shall pay twofold to his fellow. So it's saying in Shmot chapter 22, verse 8, that this is all I owe you, not the entire amount that you claim. So by mentioning a partial admission here, the verse is dealing with the custodian who claims theft, and the Torah teaches that the twofold payment mentioned further in the verse pertains only to when the custodian actually claims that part of the deposit was stolen. Okay? So the view is disputed. Rav Chia Bar Yosef said in dispute of that with Rav Yochanan. Okay? A mixture of scriptural passages is written here. In other words, he's saying, listen, there's a verse that actually belongs elsewhere, and it was mixed in this passage, dealing with an unpaid custodian and interpretation. So the verse, this is it, which qualifies the passage as basically applying, like only in a case where the defendant makes a partial admission. It says, this is what I owe you, I don't owe you everything you say. And that should have been written in a passage regarding loans. How do you know? If you look at a different pasuk, instead of Shmot chapter 22, verse 8, go to Shmot chapter 22, verse 24 to 26, because only there's a qualification that pertains to this sort of limitation of admittance, and that has to do with the loan or partial admission. It's written with respect to a loan, not with respect to a deposit. One who is sued for payment of a loan is liable to an oath only if he admits partial liability, but one who is sued for return of deposit is liable to an oath even if he issues a complete denial. So Rav Chia Bar Yosef explains that there are two distinct laws regarding liability to a derisa biblical oath. So a person who denies liability for a loan is subject to an oath only if he admits to part of the claim and denies part. So that's known, guys, as the oath of partial admission. Then, on a separate basis, a person who denies liability for deposit is liable to an oath even if he denies everything. He says, I didn't take anything, it was stolen. And that's known, according to Rashi, as the custodian's oath. So Rav Chia Bar Yosef disagrees with Rav Yochanan. And he said Because Rav Yochanan said, listen, this verse, this is all I owe you, was stated even in regarding to a custodian. But Rav Chia Bar Yosef is saying it's only regarding loans. Okay, guys, I've got 5 minutes left. I need it. Now, the reason is very interesting. So, for in fact, when the verse states this is it, which refers to partial admission, it's written with respect to loan, not with respect to deposit. One who is sued for payment of a loan is liable to an oath only if he admits partial liability. But one who is sued for return of a deposit is liable to an oath even if he issues a complete denial. And the question is, why is a loan different to a deposit? And in accordance with an explanation of Rabbah, for Rabbah said, for what reason did the Torah say that one who admits to part of a claim must swear that his denial of the other part is true? It's because there's a presumption that a person is not brazen enough to deny his obligation in the face of a creditor. So basically, guys, what Rabbah is saying is that if somebody's lent you money, then what you might be doing is, if you admit that you owe 100,000 Rand and you don't have 100,000 Rand, you think that the court's going to make you pay immediately and you panic. But you don't want to look at a guy that's really helped you out and say, I don't owe you anything. Because we'd feel embarrassed. He was the only one that stepped up when you were in trouble and helped you out. And now you're denying blankly to his face and to the court you don't owe him anything. People are generally not that brazen. So what that is, he says, no, I don't owe you all of it. I owe you about 50 grand, because he's got 50 grand. So he's doing a delay tactic. And then afterwards he turns around and says, no, I actually worked it out that I do owe you the extra 50 and I just felt ashamed and I didn't have the money, but now I have it. So it's a delay tactic. But because you feel guilty, that's why you wouldn't say outright you don't owe the money, because that's a lie. You'd want to maybe admit to some of it, get off the hook, pay in stages, whatever. But as far as the deposit is concerned, you're an unpaid custodian. So the oak's rocked off and gone to Israel. He's left you with everything to look after. He wants to sue you now. And now you're irritated because he said he was like maybe going to pay you and he didn't pay you anything. And you did all this hard work. So if you keep a little jar for yourself of Nescafe, what do you care? You've got he never helped you out of a jam. If anything, he should have paid you for the deposit you paid for looking after his place. So you would quite easily deny the whole thing because you don't own the thing. You'd be much more brazen with him than somebody that did you a huge favor. Okay? So it said that there's a presumption that a person is not so brazen as to deny his obligation to the face of his creditor. Hence, one who denies a claim entirely is believed without an oath. Since he actually owed the claimant money, he could not have been so brazen as to deny it outright, especially if he did him a favor, guys. But this one who denies only part of the claim would possibly wish to deny it entirely. And the reason he didn't is because he can't bring himself to be so brazen when the guy did him a favor, and actually would want to admit its claim in entirety to the creditor. And the reason he denies part of it is he thinks if I admit it to him regarding the entirety, he'll demand it of me immediately in the court and I don't have it. I'm almost done. I've got 2 minutes and I need it. Okay. Hence, I will evade part of the claim, at least for now, until I have the money, and then I'll pay him. The merciful one, Hashem, therefore imposed an oath upon him so that he should admit the claim in its entirety to the creditor. And that's the basis for distinguishing between one who issues a complete denial and one who admits partial liability, is that the complete denial, he must be telling the truth because he wouldn't be that brazen. Whereas in the latter, he says, oh, you bet, he could be lying. So Rav Chia Bar Yosef concludes now it's regarding a loan, and that's the reason can be said. But in the case of a deposit, the custodian can be that brazen to deny it entirely because there's no reason that the custodian would not have a complete denial because he doesn't owe him anything, and in fact maybe should have been paid. So the Torah is meant to impose an oath on the custodian even when he denies it in its entirety, and therefore that verse, this is it, this is all I owe you, qualifies the requirement for an oath applying only in the case of a partial admission to referring to a loan and not a claim of a deposit. So Rav Chia Bar Yosef disputes Rav Yochanan and asserts that a custodian swears only if he concedes partial liability on a loan, but if he denies it totally regarding a custodian, he must take an oath. or even partial. All right, guys, I'm done.
Scott, your judgment
Damon.
on your time is very good. Yeah, very
Thanks, mate.